Hello, everyone. My name is Cat Oriel with Forbes Breaking News, and today I'm here with Stan Brand, law professor and former legal counsel, general counsel to the U.S. House of Representatives. Stan, thanks so much for joining me today.
My pleasure.
So we're here today to talk about the Supreme Court ruling that came out right at 10 a.m. this morning that Trump can stay on all state ballots. So can you give me a quick overview of that case, Trump versus Anderson, what this ruling means, and just your overall thoughts and reaction to the decision?
Well, the ruling itself is fairly narrow in that it holds that no state under the 14th Amendment, Section 3, which has a provision about disqualifying people who've taken an oath to support the Constitution and then engaged in insurrection, may, hold federal office, because no state can, in a sense, impinge on the primacy of the national election for president, and that there's nothing in the 14th Amendment that appears to give the states that power. In fact, the entire thrust of the 14th Amendment in the post-Civil War period was to take away and actually intrude on state sovereignty to the extent it provided voting rights and other rights for formerly enslaved people. And so that's the straightforward ruling. The court avoided a host of other very dense questions, including whether the president is an officer as specified under under the third section, whether Trump engaged in an insurrection, and several other issues. They went to the heart of the matter, which was what is the state's power to hold him off the ballot? And they found that that they did not have that power, and that's something that one state, in effect, couldn't throw its weight around and create a cascading effect of states deciding who could get on the ballot for federal office. Mm-hmm. So that much is pretty clear from 9 people. The full court agreed with that.
Yeah, and so I know you mentioned that, this is pretty much what you were expecting, but as you said, the court has a conservative majority, so I don't think the ruling itself was a shock, but did it stand out to you that it was unanimous?
No, because although you can't put much stock in what happens at oral argument, because that's a testing phase, that's the court probing and parrying with the lawyers to suss out the nuances and the subtleties. The unanimous consensus at the oral argument seemed to be a very big suspicion about a state's power to do this. So that part wasn't surprising. What was not surprising, but maybe significant, is that 4 justices concurred in the judgment. That is, they agreed with the result, but they disagreed with how far the court went in stating that only Congress has the power through legislation to deal with this issue. The 5th section, I think, of the 14th Amendment does say Congress can enforce this by appropriate legislation. But there was a debate between the concurring justices and the per curiam opinion about whether the court should have gone that far, and in a sense ruled on something that they didn't need to achieve the result that they did.
Mm-hmm. And yeah, I saw that part. I believe Justice Barrett was the one who sort of expressed that opinion, but I think it was interesting that she made it very clear. I don't know the exact quote, but she said, like you said, the nuances, they didn't really get into it. They wanted to make sure that the justices, that Americans understood that they were ultimately united, even though that they did disagree a little bit of like how far Congress, the power that they have. So is that very common that justices will have that final message of, there might be small disagreements, but ultimately, big picture, we all agree?
Yes, concurring opinions are common. That is, where a judge or justice will say, I agree with the result, and I would have ruled this way myself, but I would have done it differently or through a different, analytical framework. Mm-hmm. And so, yes, we have a 9-0 opinion. We have a 5-4 opinion on whether all of what the court said was necessary.
Yeah. digging in more on what this means in terms of Congress's power. So then the ruling related to what Congress can do, does that mean that they actually have the power to use the 14th Amendment against Trump?
Yeah, theoretically, I think it's possible. Now, of course, remember what it takes to get something through the Congress. That would have to get through both the House and the Senate. If you looked at the experience we've had with impeachments, that's obviously a very hard thing to do when it comes to um, changing changing who's going to be in the office of president. So, yes, they have that power theoretically. The practical issue is how hard would it be for them to exercise that?
What does this mean for Trump? Forbes reporting quoted Citizens for Responsibility and Ethics in Washington, a left-leaning organization, but they said this ruling was no way a win for Trump, given that the justices didn't rule him not an insurrectionist. So do you agree overall with the assessment of what this means for Trump, that it was a win, or is this actually not that big of a win for him because of that insurrectionist piece or another part of it?
I actually don't agree with that.
Mm.
And I've heard them say, well, they didn't say he wasn't an insurrectionist. Well, I don't think logically you can assert that something they didn't say means something they meant but didn't say. Um, they avoided the insurrection question because they didn't need to get to it. And the insurrection question is very thorny because it's not defined in the amendment. And so there would have to be a proceeding or some type of adjudication of those facts. And they were unwilling to rely on what the Colorado court did to find that. In fact, they went out of their way to say, in some states, some of the evidence that the Colorado court relied on might not be admissible because it might be determined to be hearsay. So I don't subscribe to that. I think they avoided the question because they didn't need to get into it, and had they gotten into it, it was a quagmire.
Mm. Do you think it says anything at all about the Supreme Court's view of Trump in general, or this ruling completely is just independent of how justices might feel about him?
I think this is agnostic as to who runs for presidency and wins. I think it's purely about the court's interpretation of the text of the Constitution. Now, you can quibble about the legitimacy of that analysis, but I don't think the court is steered by politics in a partisan sense.
Mhm.
In fact, to have Amy Coney Barrett sort of jump the fence, if you will, and side with the liberals, to me is an indication of how that isn't the case.
Mhm. And now that this case is over and we have the ruling, can you explain the other case that we have coming up regarding Trump before the Supreme Court in April regarding presidential immunity and his attempts to overturn the 2020 election? Is
Yeah.
the ruling today at all related or affected by this, or it's completely independent?
Completely different. The question there is, to what extent, if at all, do the things that the president did in that period between the election and the inauguration constitute official acts within the outer perimeter of his line of duty sufficient to confer some type of immunity? Totally separate set of issues. There is a case pending that I think could impact his trial on the January 6th case, and that is a case the court accepted interpreting the obstruction statute that was used against some 324 rioters on January 6th, where the court is examining whether that statute is intended to apply to the type of situation that occurred at the Capitol on January 6th, as opposed to investigative proceedings that involve production of documents and other things. So that if that case were reversed by the Supreme Court, if the Court of Appeals decision was reversed by the Supreme Court, that would knock out a leg of the Trump prosecution under that same statute.
That was the end of my questions about this specific ruling today. Is there anything I didn't get to ask yet that you didn't touch on?
No, I think we we have a full plate of novel, undecided issues. We're starting to get some answers, but we're still a ways away from getting the rest of them.
Yeah, and I know that you kept a close eye on this case and the upcoming one before the Supreme Court, but I'm just wondering if you're tracking any of Trump's many legal challenges. Do you know anything
Oh
else
yeah,
about
there's
what
the case.
other?
There's the case in New York, which I've never thought much of because I think that trying to turn, payment of settlements in cases involving personal conduct are not campaign contributions by any stretch. Virtually everything would be a campaign contribution in that sense. And the federal government lost a case like that in front of a jury in North Carolina involving former Senator John Edwards. Uh, the the um, the Georgia case, to my mind, is a bit sprawling and overbroad in terms of what the prosecution is trying to do there, and that, of course, now is embroiled in a issue over whether the prosecutor had a conflict of interest. We'll probably get a resolution of that within 2 weeks, according to the judge.
Do you have any thoughts about that case? Yeah, Fannie Willis has been under a lot of drama, so I'm just curious on your takes about that.
I mean, having listened to a good bit of it, I don't think there's enough evidence to rule that the prosecutor had a conflict of interest based on, financial entanglements with the prosecutor that was hired to bring the case. Now, the judge is going to have to assess the evidence and the credibility of the witnesses and make that judgment. Um, it could go either way, but my sense was there wasn't enough there to disqualify her.
Well, thank you so much for your time today and all your thoughts.
Sure, appreciate it.